Hello, everyone. Welcome to another episode of the Lifetime Legacy Lawyer podcast. I'm your co-host, Thomas Vick, joined by Seth Wilson, the other co-host on the podcast here. Seth, how's it going today?
Thomas, we are doing great. It is late in the week as we're recording this and had a relatively busy week, which is always good. But we were talking just before we got on here how sometimes as an attorney, you spend a little bit more time in counseling mode with your clients than you do with legal. And we've had several of those kind of scenarios this week. And it's always just as we talk through the issues that we talk through on the podcast, it's always nice to have clients who come back and need that additional assistance ahead of or in addition to, I guess, the legal stuff. And you're just privileged to have that opportunity to walk alongside life with your clients.
It certainly is a privilege to walk alongside clients. Life is happening all around us as we're dealing with laws and regulations and things like that. And it's important to know those laws and regulations, but having that human touch and being able to communicate what might be the law or regulation, but it might just be practical advice that attorneys can provide from experience and, just their insight. There's really a lot of things to be gained from a client's perspective by talking to an attorney. And, I know that from my standpoint, I talk to you a lot for your perspective and experience and wisdom. And before we hopped on here, we were kind of exchanging ideas and how to better our practices. And so it's just good to be able to talk with folks and help them out from time to time.
Yeah, and honestly, that kind of acts as a really nice segue into one of your blog topics of those caregiver contracts, because I think we both are increasingly seeing those scenarios where loved ones are taking care of others and also then need to consider how are they going to help mom or dad become eligible for Medicaid. And I think this is a potential opportunity for folks that they may not consider, because often we're just giving care out of care for our loved ones. So tell us a little bit about the caregiver contract and what that concept's all about.
Yeah, so the concept of a caregiver contract is compensating your caregivers at home. And, oftentimes an adult daughter is taking care of the parents at home, and it might be that adult daughter has quit her job in order to take care of the parents. And that can have a lot of major life change to it, not only from that daughter's income standpoint, but also just a feeling of, I'm doing all this for mom and dad and I'm not getting anything out of it. So it sort of levels the playing field. And it's got some Medicaid benefits to it as well. So having a caregiver contract has a lot of benefits from a Medicaid standpoint. And, sometimes, there might be some money that's handed over to an adult daughter to take care of mom and dad, but it's off the books. And from a lawyer's perspective, you can't do that. It's really compensation for services. So a caregiver contract puts things in writing. It designates, how much the hourly rate is going to be, what kind of services are going to be provided. And then that income information is reported to the IRS. So there's an obligation on the part of the parent, or maybe the attorney, in fact, who is acting under a power of attorney, to report the income payments to the adult daughter, for instance. And it's a really good thing because, that adult daughter who quit her job to take care of mom and dad, she's not going to be paying into Social Security for however long. And so that's going to impact her not only, while she's taking care of mom and dad, but also in the future, it's going to impact what kind of credits from a Social Security perspective she might have at retirement. So there are just a lot of things that go into it and that make it a really important thing to discuss with an elder law attorney. And maybe you can talk a little bit about that and what kind of insight an attorney can bring to a caregiver contract.
Yeah, I think really in those that opportunity is really helpful to discuss what the scope of the contract's going to cover, what the expectations are, and that these are legitimate, kind of what you would call an arm's length transaction. That it's not just something being done to avoid paying for care, which is what Medicaid's concerned about if they're going to look at a clawback or something like that. But that would really say these services are needed. They are clearly defined as to what they are. Other people could sort of, if there's other family members around, they can sort of hold the caregiver accountable if necessary to provide that care as well. But there are just a multitude of scenarios that need to be thought through and addressed in the agreement so that you don't unwittingly step out of bounds, so to speak, as you're walking through this, but can be a great thing to really give that caregiver true sort of economical support through this time while also meeting the goal of helping mom or dad become eligible.
Yeah, absolutely. And we kind of have already hinted at the idea of, you got to report these payments to the IRS, their tax considerations. So the daughter would, in my example, would have to be paying taxes, self-employment taxes for the payments that she receives to take care of mom and dad. But that's a good thing. Everything's kind of on the up and up whenever you have a caregiver contract and you execute it properly. One of the great benefits of a caregiver contract is you can show to Indiana Medicaid, FSSA, that these payments to the daughter are actually legit. They're not just gifts. They're not gifts to the daughter. They're actually compensation for services, and thus they're parents are receiving fair market value back in a way for the services that for the payments that they're providing. And what that can do, depending on the circumstances, is it can lower countable resources. Maybe there isn't a whole lot of money involved in the parent's bank account, but they have too much from a Medicaid standpoint to achieve Medicaid status. And so you could execute a caregiver agreement and then spend down some money before they're able to actually get on Medicaid, and that can kind of transition payments over to the adult daughter or whoever the caregiver might be, and that can be a great way of doing that. But sometimes, there aren't those funds available, and there may be some other options available. Long-term care insurance is one of those options. If the parents have long-term care insurance, taking advantage of the benefit from that could be an option. Or it might be applying for what has been called Indiana Medicaid waiver. That may be an option as well. And even within Medicaid waiver, there are programs called structured caregiving where some family members can receive payment for taking care of mom and dad. And that's a great way of planning as well. And we've talked in recent podcasts, we won't go into it in detail right now, but there's a waiting list to get on Medicaid waiver. So if you've got a loved one that is on kind of that edge of needing care, go ahead and get them on Medicaid waiver's wait list so that you can get services in place as soon as possible.
Yeah, and that kind of ties into the other topic we wanted to talk about today, which is what is the Medicaid snapshot date? How does that work, and why is that date so important?
Yeah, and I'll try to go through it with the headings in mind on the blog article. The first question is, why is the snapshot date important? Well, that's what determines how much a community spouse, in other words, the healthy spouse that doesn't need long-term care, how much that community spouse gets to keep once the unhealthy spouse, the institutionalized spouse, is in the nursing home or on Medicaid waiver. And the general rule is you get to keep about half. That's what's called the community spouse resource allowance. So the rules are such that the snapshot date determines kind of what your level of assets are, and then you've got to be under half of that at the time that you apply for Medicaid for the unhealthy spouse. And so what is the snapshot date? The snapshot date is the first day of a 30-day period of continuous institutionalization that happens after approximately 1989. It's a very specific rule. I forget the exact date on it. I want to say it's like September something in 1989. But for any period of 30 days in which a spouse has been in a hospital, rehab facility, or nursing home for at least 30 days, that first day of institutionalization is your snapshot date. So we take a look at how, what were the value of the assets at that point in time, and then elder law attorneys will say, well, you need to be under half of that, generally speaking. It's capped out at about 100. I guess it would be about $300,000. So you're able to keep about $150,000. Even if you're above $300,000 of assets, you only get to keep half of 300, essentially, as the rules are right now. So that's what the snapshot date is, and it's really important because that's where we begin to plan around, well, how do we protect the other half of assets?
Well, it's great. And as you can no doubt tell, as you're thinking about all of these issues, these are very technical in nature and very fact specific. And having a thorough understanding of the assets, knowing what income is coming in, where are the investments, what might these individuals still be inheriting from someone else that could change all of these dynamics. But it really is kind of what starts the clock in terms of, boy, we really got to get all this stuff nailed down and get all this information gathered together. So I think one encouragement that I've been consistent in providing to clients over time is we need to be really organized as time progresses and making sure that you have access to all of the necessary information, be that bank account access or retirement fund access or those kind of things, so that you can get to the necessary information in terms of statements and those kind of things that will help establish what those numbers look like so that effective planning can be done to keep that qualification in mind.
Definitely. And fortunately, I haven't had a case where somebody was institutionalized in 1992 and that's now the snapshot date, some random day in 1992. Who has records from that point in time? I haven't come across that.
Yeah, it just always underscores to me the importance of having access to an elder law attorney, because someone who is well versed in the various rules and regulations associated with this type of planning is so key, because you can try to figure it out on your own, but there's always sort of an exception to the rule, and that may not be readily available to you on a quick internet search. And I think there's a lot of good information available, but nothing can substitute for actually picking up the phone and talking through this situation with an experienced attorney, because you will say something in that meeting that will draw out a question that will help identify other things that we may have as available options. So I would encourage those who are in this scenario to not hesitate to reach out and call someone and get some questions answered. Well, this is just such can be an overwhelming time for folks, especially if you have been named as an executor of someone's will. And where I see this more as a sort of stressful scenario is in those scenarios where you have sort of a family dynamic where maybe the individual who wrote the will nominated a family member, but not an immediate family member, to serve in a role. And now you're sort of caught in between all the different questions that may be going on. They're not necessarily a dispute or anything, but everybody wants information and doesn't know who to ask. And the estate itself isn't opened up yet. So it just creates kind of this initial, it's sort of controlled chaos a little bit, because you have the passing of a loved one and you're dealing with all of the logistics around the services and those kind of things that may be occurring. And then all of a sudden you feel like you're responsible for wrapping up all the bills and all those things and still trying to process the loss that's occurring. And so it's okay in that moment to go, boy, this is a little more than I anticipated at the time, and trying to figure out, what do I do next? And so really that first call to the attorney's office is hopefully a time of just, I've got some support around me now. The attorney can be sort of the go-between to handle a lot of the questions that may arise from different family members who aren't quite sure what's going on. So just offer that as sort of a, if you're in this position and you've been named as an executor and you're not exactly sure what to do, figure out who the drafting attorney was for the plan and give that office a call, or call the attorney that you're comfortable with using. Because as your article kind of pointed out on the blog this week, even if it's more modest estate in terms of financial, that doesn't diminish the life that was involved. And there's going to be questions about items of sentimental value and personal property and those kind of things, and needing access to get pictures for the funeral or the service and those kind of things. So there's a lot to do on the front end. So that's kind of point number one. I guess I would encourage someone is to recognize that it can be a little bit of a challenge there, but getting that first call made and that appointment on the calendar with the attorney can help say, hey, I'm going to go see the lawyer. We're going to get all the questions answered. Let's just focus on step one, which is sort of starting the process of grieving the loss of the loved one. Yeah, and I think it's important because I see a lot of times where folks will kind of take the ball and start running with it without having a destination in mind. And then they run into a roadblock, and then there's some frustration because we thought we were doing this and we were supposed to, when really we kind of skipped maybe the first step, which was determining if an estate needed to be opened or not, whether there was a will in place or whether this is a situation where it's an intestate situation for probate purposes. And so the attorney can really help pave the road a little bit, to borrow that analogy, to help give you mile markers along the way to say, yeah, this is going to be step one. This is going to be step two. Once you've gotten that done, get that back to me. Then we'll discuss the next step. So you can we're able to, in our experience, sort of lay out those bite-sized projects rather than saying you got to solve everything all at once, which for anyone is overwhelming, especially in a time of grief already. So really kind of that roadmap and that experience. And again, we have some more objectivity because we're not directly involved most of the time in the family situation. And so we can kind of look at things more of a factual base and bring some perspective to the table that may be helpful in those more trying or challenging times. Yeah. Yeah. And I would point out too, if you do have a will in place, if it's an original will and it's sealed up or has a sticker on it or is in an envelope, don't open the original will. let's look for a copy if we can, and find that because the original will is sealed for a reason. It's there to be that ultimate proof of what the testator's intent was. And so we don't want to open that up until absolutely necessary. And so if it's the only copy, better call the lawyer and figure out what the right steps are in that moment, and kind of figure out how to do that without jeopardizing the authenticity of that will and those kind of things. And so, yeah, there's just so many little questions that I think a 30-minute conversation with a lawyer would really get you pointed in the right direction if that's the cause. And so hopefully you've got a local attorney that you can turn to that would be able to walk you through a lot of those initial questions and just give you, like I say, that roadmap of, okay, here's the plan and here's how we're going to get from this destination to our ultimate intended destination. Thomas, we are located here in the heart of Hamilton County in Noblesville, Indiana, and that's our web address, noblesvilleattorney.com. How about yourself? Thanks, Thomas.